Our first class speaker. It's my honor to introduce Justice Peterson of the Georgia Supreme Court. Let me tell you a few interesting things about him. I've got it written down in my handwriting. He was appointed by Governor Nathan Deal to the Georgia Supreme Court effective 1 January 2017. Previously, he served on the Georgia Court of Appeals as a judge. He got a promotion. He graduated from Kennesaw State University in 2001. While at KSU, he served as president of student body. Well, he must have done well at KSU because he was admitted on his own merits to Harvard Law School. Wow. Graduated in 2004. After graduation, he served as a law clerk, also known as a staff attorney, to a federal judge on the 11th Circuit Court of Appeals. Then he practiced at King & Spalding, a big, fancy, silk-stocking law firm in Atlanta. I dated Sarah McIntyre, and her father was a lawyer's partner at King & Spalding, so I've always been in awe of King & Spalding. He's got many honors you can see online, but the most important and interesting thing about that, he is a product of Cobb County, Georgia. He grew up here, schooled here, lives here today. The only one thing of negative about it, he doesn't belong to a civic club. And you know, that is an error. It's a reversible error. We can reverse it and make it right, but he's active in his church, he says, but that still needs to be active in his civic club. And I told him that Justice Harris Hines, his co-worker down there, was past president of this club, and that since you are a product of Cobb County, you need to come home to your home club, the Marietta Kiwanis Club.
Amen.
You started? Oh, you started. Oh, Andy, you're so good.
Early's on time.
Okay. And now, what is he going to talk about today? I asked him to talk about what did he do? Demystify the Georgia Supreme Court. What does a justice do in an average day? And he told me he's going to. I asked him to talk, but the truth is he can talk about whatever he wants to, okay? He's at the top of the food chain. He has the power to reverse my brother. If my brother commits, now there are two types of error. One is called harmless error, and one is called reversible error. And my brother says that when he does error, which is seldom, but it happens, it's harmless. So, but he makes the decision whether it's harmful or harmless. Without further ado, give it up to one of our own, Justice Peterson.
Well, thank you very much for that kind introduction. Matt actually made the same point about not belonging to a civic club when we spoke earlier this week. I pointed out to him that my 11-year-old and 8-year-old viewed themselves as at least as demanding as a civic club. So, but it really is an honor to be here today. I am from Cobb County. I grew up in South Cobb. I played Little League at Oregon Park in West Cobb. I went to college in North Cobb. I live in East Cobb. So I've covered all of the bases. And as a judge who serves statewide, I love all of Georgia, but Cobb is a very, very special place. It is special to me because it's home, but it's also special because it's just a wonderful place to live. And I love serving alongside my good friend Harris Hines, who never meant anything about Cobb County that he didn't like. I think I was one of his favorite justices. Largely because I lived a little bit down the street. Keith Blackwell also is a justice on the Supreme Court from Cobb County, and Harold Melton, our current Chief Justice, who I believe spoke with y'all not long ago, went to high school in Cobb, spent a lot of time here before he moved to DeKalb, and his mother served as a bailiff in Judge Rob Leonard's courtroom just down the street at the Superior Court. So it's a wonderful place to be. When I think of Cobb County, I think of the Marietta Kiwanis Club. And I think of the Marietta Kiwanis Club because Harris Hines was always bragging on you guys. If I heard one story about Marietta Kiwanis, I heard 100 stories during the time we served together. I promise not to tell any of them today. But he had such a high regard for the important work that each of you do to make this such a wonderful community. And I want you to know that as a member of this community, I am deeply grateful to each of you for the work that you've done to make it such a great place to live. So thank you. Cobb has gone through a lot of changes over the last few years. When we moved to Cobb County when I was 1.5, my dad worked for the Army and had been stationed at the Presidio in San Francisco and was reassigned out here in 1980. There was a farm across the street from our newly built subdivision in South Cobb when we moved in. There is now not a farm within 15 or 20 miles of where my parents' house is. But as much change as Cobb County has gone through over the almost 40 years that I've lived here, the Georgia Supreme Court has gone through almost that much change in the last 2 years. Justice Hines was the junior justice of the Georgia Supreme Court for 13 years. The court had no turnover for a 13-year period, which is the longest serving court that remained the same in the country at that time. Since January of 2017, 5 of the 9 of us have joined the court. You've had a majority of the court turnover in less than 3 years. That is a really incredible change. It is difficult to overstate how significant that is. At the same time, courts are places that value precedent and tradition and doing things the way that they've been done because that's the way they've been done. Because stability is a really important part of our legal system. And so it has been great to learn from people like Harris Hines, like Robert Benham, like Carol Hunstein, and like Harold Melton while we've been there. So while the faces and the names have changed on the court, I certainly hope our approach has not. I want to talk very briefly about state courts and the importance of state courts, because typically when we hear about courts, we hear about the United States Supreme Court. And the United States Supreme Court is, of course, a vitally important court. It's the final word on the meaning of the federal Constitution. It's the final word on the meaning of federal law, and it decides a lot of the really important issues of the day, or at least a lot of the issues of the day that make the headlines. But your state courts do most of the work that actually affects your everyday life. Just to give you a sense of comparison, there are about 400,000 cases filed every year in federal court across the country. There are over 84 million cases filed every year across the country in state courts. In fact, in Georgia alone, 2 years ago, which was the last year we have full data for, 400,000 cases filed in federal courts nationally, 2.3 million cases filed in Georgia State Court. 400,000 of those were filed in Georgia Superior Court alone. So your Georgia Superior Courts have as many cases filed a year as all of the federal courts in the country. And the kind of cases those are the cases that matter the most to most of your lives. Adoption, divorce, property, wills. Almost all criminal cases are state cases. There's about 80,000 federal criminal cases a year. There's almost 17 million state criminal cases a year. Driving, education, I mean, almost anything that you deal with on a daily basis is a function of state or local law as opposed to federal law. But we don't think a whole lot about state courts, and we really ought to, because your superior courts, your state courts, your juvenile courts, your probate courts, they do a ton of really important but usually unthought about work, unless you happen to be a lawyer or you happen to be in the court. Georgia's history of the court system is, I think, a particularly interesting one. When Georgia was founded as a colony, lawyers were not permitted there were three things that were not allowed in the Georgia colonies. Slavery was prohibited, rum was prohibited, and lawyers were prohibited. Well, to our eternal shame, the prohibition on slavery was relaxed, and then the prohibition on lawyers were relaxed, and once lawyers came in, rum had to be allowed too. But for a long time, the highest level of court we had was superior court. Even after the Revolution and Georgia becoming, a state as part of the United States, and Georgia's first constitution as a state as opposed to a colony, we only had superior courts. We had superior courts, we also had state courts and other courts, but the highest court was a superior court. And if you didn't like the ruling you got from your superior court judge, you could appeal. But your appeal was to that superior court judge who just ruled against you. So unless lightning strikes, you did not have a high degree of success on appeal. But you also had a number of superior courts across the state, and without a higher court to appeal to, you started to see a patchwork of different interpretations of the law. Well, that's not a good thing to have for the stability of a legal system. So the superior court judges decided, well, look, we need to do something about that. What we'll do about it is we'll get together in an annual conference, and we'll talk about the hard issues that may divide us, and we'll vote on what the right answer is. So they did that for a while, and it worked really well until one year they decided that an act of the General Assembly was unconstitutional and struck it down. The very next year, the General Assembly passed a resolution prohibiting the Superior Court judges of Georgia from ever meeting in conference again. So they didn't. But again, that patchwork of differing interpretations started to develop. And so the idea that we should have a Supreme Court, like the other states, started to really get some traction. Finally, in 1835, a constitutional amendment was adopted allowing for the creation of a Supreme Court. We were the last of the original 13 colonies to get a Supreme Court. And even then, that amendment didn't create the Supreme Court, it simply allowed the court to be created by the General Assembly, which wouldn't happen for another 10 years. In 1845, it was the first year of the Supreme Court, and the governor, at the time when he signed the bill, said that he was confident that the Supreme Court would be able to resolve all of the unresolved questions of law in about 10 years, and then they could just be disbanded. Well, 170 years later, we're still going strong, and I can assure you we have lots of still unresolved questions of law. We also have an intermediate appellate court, which was the Georgia Court of Appeals, which was created in 1906. Shortly after, a justice of the Supreme Court resigned in a letter to the governor in which he said he was resigning from exhaustion. So the Georgia appellate courts have always worked very, very hard. In fact, the Georgia Supreme Court has been named by not simply ourselves, but several independent researchers as the hardest working state Supreme Court in the country. The University of Chicago in 2006 did a study where they concluded we were the most productive state Supreme Court in the country. And then in 2016, the Massachusetts Supreme Judicial Court did sort of the same sort of survey. And when they got our numbers, they actually called us back and they said, wait, these look wrong. Are you sure? I said, yeah, we did in fact write all of those opinions. And we were in terms of caseload, in terms of most opinions, in terms of most opinions per judge, the highest, hardest working Supreme Court in the country by a wide margin. We average about 358 opinions a year over the past 20 years. By frame of reference, the U.S. Supreme Court last year had 76 opinions. In addition to that, we have about 2,000 cases total, including petitions for a writ of certiorari from the Court of Appeals, habeas petitions from people who are in jail. We oversee all of the attorney discipline in Georgia, so any disciplinary cases get appealed to us. We have all direct appellate jurisdiction over all murder cases. All constitutional questions, where there's a constitutional challenge to a state statute, or a novel question of the constitutionality of a local ordinance, or just the meaning of a constitutional provision that's not previously been interpreted. And the U.S. Supreme Court is the final word on the U.S. Constitution, but we are the final word on the meaning of state law and the state constitution. Not even the U.S. Supreme Court can overrule what our court says about the meaning of the Georgia Constitution. So we have the second most oral arguments of any Supreme Court in the country other than New York. We generally allow, if you have a case in our court and you ask for argument, we will give it to you automatically as long as you ask for it timely. And as the head of the judicial system in Georgia, we have a lot of administrative responsibilities. We oversee admission to the bar exam. In fact, I edit the bar exam every year. We oversee the state bar. We're responsible for approving all changes to the rules of the different classes of courts, so all the superior court rules and the probate court rules and every other class of courts, we have to approve those. We are active with the Judicial Qualifications Commission, the agency that is responsible for disciplining judges. We have to approve their rules, and their decisions can be appealed to us. There's a whole host of administrative responsibilities that go along with being the high court of the state. And in between all of that, we're writing our 350 opinions, which works out to about one a day, deciding important questions of state constitutional law and your murders, your election cases, and other things. Matt asked me to talk very briefly just about what kind of a day looks like. And there is no typical day, but there's a typical couple of weeks. And so, as a court, there are 9 of us. All 9 of us participate in every decision that we make. So when we have about 2,000 matters that have to be disposed of every year, all 9 of us are participating in disposing of each of those 2,000 matters. And we do that primarily through what we call our bank meeting. We'll meet B-A-N-C, not K. We're not going into business to compete with anybody in the room, we promise. We all meet in a room for about 5 hours every other Thursday to go over, at each meeting we'll discuss maybe 25 written opinions that circulated in advance that each of us have edited and gone by the author and said, well, I think I'm with you, but you're gonna have to change this to say this instead. And then somebody else comes in and says, I think I'm with you, but you're gonna have to change that to say the opposite thing. And if you're the poor author and you've got 3 or 4 different competing edits going on simultaneously, it can be a little challenging. You try to get everybody in a room and hammer it out. But that process goes on every 2 weeks. We'll sit there, we'll vote on 25 final opinions after 8 other justices have streamed through my office for about a week and a half and try to make them all happy, or at least 4 of them happy, because you gotta get to 5 to have a majority. But in that meeting, we'll also vote on 30 to 40 petitions for writ of certiorari, which is the request for us to take a case from the lower court. We'll vote on 30 or 40 habeas petitions. We'll vote on 5 or 6 disciplinary opinions for attorneys from the state bar. And then we'll have an administrative bank where we go over all of the administrative issues and vote on things that affect the judicial system. And that goes on every other week. The intervening week, we have oral argument. We have oral argument usually every 2 weeks, twice a month. And so we'll have argument Tuesday and Wednesday, usually morning and afternoon, both days. And so Monday is preparation for argument. Then Thursday and Friday is trying to finish your opinions to get them circulated by Friday so they can be on the bank meeting for the next week. And then the next week you do it all over again. And in between, you go off to meetings with the state bar, meet with the board of governors, go over their rules, go over their significant issues. And it just goes on and on and on. But it is an unbelievable amount of fun for somebody who's a nerd like I am. Because at the end of the day, we're entrusted with overseeing the rule of law in this state. And that is such an important thing for any community. Civilization only works when the rule of law is upheld, when it's respected, when laws are applied the way that they're written, not the way that we prefer them to be, and so we just make it up. And in Georgia, we have a Georgia Constitution, not simply a U.S. Constitution. The Georgia Constitution is something that each of you get to participate in making. The U.S. Constitution is almost impossible to amend. You have to have 2/3 of each House of Congress, and then 3/4 of the states have to ratify it. In Georgia, each body of the General Assembly has to pass an amendment by 2/3, and then you get to vote on it. And so every November election, every other year, there will usually be 2 or 3 or 4 or 7 amendments written in incomprehensible language that you have to decide whether to approve or vote down. But we think of the founders of America, the founders of the Constitution, James Madison, and George Washington, and Benjamin Franklin. They wrote the United States Constitution, and by golly, am I glad they did. But you get to participate in the creation of the Georgia Constitution, and I think that's really cool. And that Constitution, you should read it sometime. It's a lot longer than the U.S. Constitution because it has a lot more ground to cover. But it talks about education, and it talks about taxation, and it talks about local governments and how all of that is supposed to work. And I get to go to work and get paid by the taxpayers to decide what that means. And I am just incredibly blessed to have the opportunity to do that. And I'm incredibly blessed to have the opportunity to talk to you this morning. I can go on about the Georgia Constitution or other matters indefinitely, but I am told you have other things you need to do today. So I'm going to stop now. I'd be delighted to take any questions if anyone has any.
As interested in the amendment process of the Constitution, what the voter sees on that ballot is a summary, and it seems to me some of those summaries don't really describe what this amendment means. What's the legality involved in that?
So that is a really interesting question. What you actually see on the ballot when you go to vote is a summary, and there's actually 2 summaries. There's a bolded, short, I believe it's less than 15-word summary at the top. And that's actually written by a committee of the Attorney General, the Governor, the Speaker, and the Lieutenant Governor. And I used to participate in that process when I worked for Governor Perdue back in the day. Then there's the longer summary, which is written between the Attorney General and the Office of Legislative Counsel. Those summaries, I'm sure people always do their best, but sometimes it's very difficult to explain a really complicated constitutional amendment in, that much text, which is why, and this process is fully laid out in the Georgia Constitution, which is why when you go and you get your sample ballot, there's usually information. If you want to see the full text of the amendment, here's where you go. The full text is supposed to be available publicly in a variety of spaces. These days with the internet, it's much more easily accessible, but you sometimes, even when you sit down and you read the actual text, if it's something dealing with, say, local government taxation power or something like that, it takes a few reads to figure out what exactly is going on. I will say though, it's much easier today than it used to be. We used to have, we have local laws that the General Assembly passes that only apply to specific local governments. We used to have local constitutional amendments also. And so you have to be voting on a constitutional amendment that only affected one particular county. And we did away with that in our most recent constitution. Yes, sir.
With as busy as the Supreme Court is, why do judges sometimes feel the need to issue a gigantic dissent rather than just keep their opinion to themselves? They've already lost. Are they trying to make sure everybody knows what their clear opinion is in case they're being looked at for some other type of federal position? I've always wondered that.
So, that's a great question. I will say 99% of our opinions are unanimous.
Okay.
They don't always start off that way. In fact, a number of the opinions that get written start off as dissents, and sometimes they capture the majority of the court. So sometimes you write a lot because you're trying to convince your colleagues. But sometimes it's because you're trying to convince the General Assembly to change the law, or a future Supreme Court to change the opinion, or because my view has always been, if I don't feel myself able to join a majority opinion, I owe it to the rest of my colleagues that I'm disagreeing with to explain why, to show at least that I believe I have a good reason, that my oath to the Constitution and the law as I understand it precludes me from going along. Because if I don't have a good reason, then I need to be in that majority opinion. So I think that's usually what it is. We don't see many gigantic dissents. I think it's been probably 10 years since we've had one more than 10 pages or so. But, yes, sir.
You said that the Supreme Court was responsible for the rule of law in Georgia, but yet recently we have seen what appears to be, and we may not have all the facts, abuse of power by the Speaker of the House in delaying swift justice. And I just wondered if you had a comment on that.
So the question is about a news story that's been out there about the Speaker of the Georgia House. I don't have a comment on that specific issue. What I will say is there's a Georgia law that's been on the books for about 100 years that allows sitting legislators to request a continuance in their case when they have legislative business. And there's room for debate as to how that should be properly calibrated. But I think we would all agree that when you've elected someone to represent you in the House or the Senate, you want them to be there voting for you, representing you during, doing the job you've elected them to do. But we also have part-time legislators in this state. They're in session 2 to 3 months a year, and we pay them $17,000. And so long as we have a part-time legislature, we have to recognize that there's a balance between having them present for the legislative work, but also they've got another job because we expect them to have another job, because we think having citizen legislators in this state is a good thing. So I'll leave it at that. Yes, sir.
We have the United States Bill of Rights, we have the Georgia Bill of Rights. How do they work together? Can you have more rights on the Georgia law than on the federal law?
That's a great question. It is one of my favorite issues to talk about. I didn't specifically set that. So we have two constitutions. We have a Georgia Constitution and a U.S. Constitution. The government of Georgia, the state, all of the local governments, is required by the Supremacy Clause of the United States Constitution to follow federal law. So the United States Constitution is something that is binding on the state of Georgia, and if you have a right under the Bill of Rights in the United States Constitution, Georgia cannot violate that right. But the Bill of Rights in the Georgia Constitution don't have to be the same rights. We've got many very similar provisions, but they don't have to mean the same thing. The U.S. Constitution says that the Third Amendment prohibits the government from quartering troops in your house. We do not have a provision in the Georgia Constitution regarding quartering troops in your house. At the same time, we have a lot of provisions in the Georgia Constitution that don't exist in the U.S. Constitution. Over time, we've interpreted those provisions, many of them, to provide greater rights, greater limitations on what government can do to you than the U.S. Constitution provides. And because of your role, the role that you play in the creation of the Georgia Constitution, that really gives you more of a direct say in what kind of society you want to live in here. If you find government doing something that you don't think it ought to be doing, but the U.S. Constitution doesn't speak to it, you can propose a constitutional amendment tomorrow. That I think is one more way that we preserve liberty in this state. You know, and it was the system that the framers of the US Constitution came up with, this idea of federalism, having the multiple levels of government, winds up being more protective of individual liberty and the rule of law than simply having one top-down federal system. Great question. Anything else? Well, it's been an honor to be here with you today. Thank you so much.
Here as a guest to speak to our club today, and it's a tradition that we have at Kiwanis Club, is that we dedicate a book to a local elementary school, and today it's A.L. Burris Elementary School. So we ask that you sign this to commemorate your deed.
This is awesome.
My kids go to a local elementary school, so.
Oh, yeah, I'll tell you. Yeah. How it works. It's got- What does a Supreme Court justice do? It's Justice Roberts.
Thank you very much.
Okay, thank you very much. We've got a little bit of